Insurance claim for marine collision. Court examined constructive total loss, responsibilities of the insured, and notification. Instance of marine collision produce a wide range of legal issues, including question of allocation of liability, entitlement to damage, and factual and expert evidence. One of the key issues facing parties involved in a marine collision case is whether the event is covered by insurance, especially given the extensive costs often involved in the repair or total loss of the vessel. In PT Adidaya Energy Mandiri versus MS First Capital Insurance Pte Ltd, the Singapore International Commercial Court SICC was faced with a claim for constructive total loss CTL under a marine insurance policy arising from collision damage. In reaching its decision, the SICC had to consider a number of issues relating to the insurance coverage for the claim, including the proving of CTL, late notice of abandonment (NOA), and the responsibilities of the insured under certain warranties provided in the policy, and compliance with the policy's claim notification requirement. The SICC held that the insurer wasn't liable to the insured, finding that the collision damage didn't result in a CTL and that the NOA wasn't given within a reasonable time. The SICC also found that the insured had breached the warranties and had not notified the insurer of a potential claim within the timeline prescribed under the policy, which was a condition precedent to liability. The SICC's decision highlights some common issues that may arise in a marine insurance claim for collision damage, as well as the substantive and procedural requirements that must be complied with to succeed in the claim. The insurer was successfully represented by Jainil Pandari, Alexander Georgiev, Christine Angie, and Nathaniel. In this update, we provide a summary of the key points of the judgment and the SICC's consideration of the issues above. Brief facts: the plaintiff company had been engaged to provide, operate, and maintain a single-point mooring buoy (SPM) deployed in an offshore gas field in Myanmar. The SPM was used as a mooring for a storage tanker attached to its vessel and retrieved and transferred condensate from the field to the vessel. The plaintiff has insured the SPM with the defendant insurer for total loss only, including CTL, under a contract of marine insurance. As a result of a number of collisions between the SPM and the vessel, the SPM was damaged and leaked seawater. Initial repairs were conducted by the plaintiff in situ to restore its watertight integrity and rectify the damage. The plaintiff subsequently obtained quotation for further onshore repairs to the SPM. As this quotation exceeded the insured value of the SPM insured value, the plaintiff tendered the NOA to the defendant around 5 months later. The defendant rejected the NOA and issues arose as to whether the further repairs were necessary. The plaintiff subsequently sold the SPM at a considerable undervalue and continued to use it at all times until the sale. In the suit, the plaintiff claimed from the defendant the insured value of the SPM as a CTL on the basis that the cost of repair required to restore the SPM exceeded the insured value. The defendant denied liability on a number of different grounds. Holding of the SICC. SICC held in favor of the defendant, finding it not liable for the insured value for the following reason. The plaintiff had breached certain warranties in the policy. The plaintiff had failed to give written notice of the incident giving rise to a claim in time. The SPM wasn't a CTL as the reasonable cost of repair didn't exceed the insured value. The plaintiff could not claim for CTL as the NOA was tendered late, and the plaintiff had waived its right to abandon the SPM and claim for CTL. Warranties. The defendant relied on 2 warranties in the policy which applied to damage to the SPM while engaged in operational activities. Clause 1. The SPM is only to be operated by and under the supervision of suitably trained and authorized personnel. Clause 8. Suitable precaution and preservation or maintenance measures to be adopted when storing, handling, transporting, and operating the SPM. The SICC found on the fact that Clause 8 was breached as a static tow wasn't utilized to hold the vessel at all times to prevent it from colliding into the SPM. Further, the vessel, its master, officers, and crew had failed to take adequate measures to ensure proper station keeping to prevent the vessel from moving toward and colliding with the SPM. Clause 1 was also breached as the plaintiff failed to produce evidence of certification and trading to show that the master, officers, and crew of the vessel who were responsible for station keeping were suitably trained and authorized. Notably, the court found that the Clause 1 and Clause 8 warranties applied despite the fact that it was the master of the vessel who was responsible for maintaining station keeping and avoiding collision with the SPM, and that the vessel was owned by a third party over whose employees the plaintiff had no control. The plaintiff had warranted a state of affairs, and the SICC held that the plaintiff was in breach of the warranty if the state of affairs didn't occur. The plaintiff wasn't only under a duty not to breach the warranties by its own action, but had promised that the warranties would not be breached, whether by itself or anyone else. It would not matter if the breach of warranty occurred by reason of the fault of a third party, or if the plaintiff had delegated its duties. As the warranties had been breached, the defendant had a complete defense to the plaintiff claim. Notification of claim. The policy included a condition precedent that the plaintiff would notify the defendant within 30 days after becoming aware of any incident giving rise to a claim which may be covered under the policy. This included awareness of any incident giving rise to a claim which might result in total loss or CTL. The plaintiff had notified the defendant of the potential claim on 5 September 2008. However, the SICC found that the plaintiff was aware of the collision incident and the damage to said SPM by 17 July 2018, more than 30 days before the notification. It didn't matter that the plaintiff, before receiving the quotation for further repair, could reasonably believe that the cost of repair would not exceed the insured sum, or that the plaintiff didn't see the incident as likely to give rise to a total loss.